We all know that Kyle Rittenhouse has decided to testify in his own defense at his criminal trial. Should you testify in your defense at your criminal trial? My name is Tony Naro. I'm a criminal defense attorney in Nashua, New Hampshire. Let's get into it. First of all, the decision of whether or not to testify in your own defense at your criminal trial really needs to be made on a case-by-case basis after a long and thorough discussion with your criminal defense attorney. That being said, there's some basic considerations that we'll talk about today. First, you need to understand that the government carries the burden of proof in a criminal trial. They accused you of doing something wrong. They have to prove it. That's your constitutional right. And you also have a constitutional right to remain silent. You're presumed innocent, and you don't have to testify. You don't have to present any evidence. It's on the government to prove that you're guilty. The jury will be instructed, if you don't testify, that it cannot use your silence against you in its deliberations. And if your defense attorney has the opportunity to voir dire the jurors, which means speak to the jury prior to selecting which jurors will sit on your case, they will also talk to them about that principle of law, as will the court. Now, second, you should consider what your defense is. Is it about the credibility of the alleged victim? Is it something where you have to testify in order for your defense to be credible? Let's say in an alibi, for example. Though not every alibi case requires you to testify, some may call for it. But let's say this is a sexual assault allegation. You're wrongly accused. The allegations are false, and the jury is going to be able to tell they're false through your attorney's cross-examination of the victim and maybe examination of other witnesses and presentation of other evidence. Maybe there's social media evidence out there. Maybe there's video surveillance that shows that you weren't where they said you were when the assault happened. Do you need to testify? If you're attacking the alleged victim's credibility and only they testify, then the jury is doing one thing and one thing only. They are judging the credibility of the alleged victim and deciding whether or not they believe that alleged victim's testimony beyond a reasonable doubt after your attorney has cross-examined them. Now, if you testify, the jury no longer is deciding whether or not they believe the alleged victim. Now they're doing a credibility determination between you and the alleged victim. Do they believe the victim over you? Do they believe you over the victim? And now they're choosing between two witnesses rather than just focusing on whether or not the alleged victim was credible. There's a big difference there, and it's something to consider when deciding whether or not to testify. Second, do you need to testify? Can you get in the evidence to win your case without having to get on the stand? Because if you can, then maybe there's no need to testify and subject yourself to cross-examination. Now, fourth, while we're talking about cross-examination, you have to ask yourself, are there areas of cross-examination that the prosecutor will go down to try to discredit me? To try to twist my words, to distort my testimony and lead the jury to believe that I'm not credible, even though you're telling the truth. For example, did you make any inconsistent statements? While some inconsistent statements might seem small, a skilled prosecutor can exploit them and argue to a jury that you're not credible because of those inconsistencies. Do you have a prior criminal record? Do you have any convictions for felonies? Because if you do, those may become admissible if you testify. And is that something you want the jury to know about when determining whether or not you're guilty or not guilty? Fifth, prior to trial, did your attorney suppress any statements that were made by you to the police? Because if so, and you testify, in some cases, the government may be able to introduce those prior statements during your testimony to impeach your credibility if those statements are inconsistent with your testimony. In the end, whether or not to testify is a very fact-sensitive and personal decision that you need to make after a long and thorough consultation with your criminal defense attorney. If you have any questions and you have a criminal case pending in New Hampshire, please feel free to reach out. And of course, knowledge is power, so I appreciate you commenting and sharing this video.